was
Well,
speaking.
we are agreeing to what she said, so if you would just allow us to speak for once, then we could just agree to
I
that
would
amount.
appreciate if you would not interrupt me. I have had about enough of
And
you,
that's
so please do not
totally
interrupt me when I'm
fine.
speaking.
Your Honor,
In today's case, I dug up a very spicy TPO hearing from Judge Manning. Dad and his ex are working out child support and visitation, while his current girlfriend is acting as his lawyer. But when I looked her up to see if they still were together before making this video, what I found about where things stand today will absolutely shock you.
it sounds like it. I sent an email. I know that you've been in court, but so we were filling out the affidavit for Mr. Breland, but considering that he is self-employed and has his own company, he has, like, say, his maintenance records. He has to keep them in the truck because of DOT and stuff like that. So we were having to get a lot of the stuff together so that we could accurately fill out the affidavit. So it was taking longer than we thought. So I have not submitted one because I wanted to make sure that we got the information right. I understand there's probably going to be, you want to do an award of child support. But I, we understand that, he understands that, and has been paying for his children since they were born. And so I had originally sent an email just saying that if we could get, send it to you over the weekend or first thing Monday, so that way that we could get all those records and everything together. Because, say for instance, last month, alone he had a breakdown where he had, I think, like $13,000 worth of expenses for the truck, stuff like that we just didn't want to, since we've got to do the gross and net, and it's not just a paperwork of a W-2 or anything like that. It was just we wanted to make sure we got it right for you.
But I'm willing to pay
Yeah.
whatever she sees fit.
Well, she
Yes, so, Ms. Montgomery, I printed out.
Yes, Your Honor. Good morning. I guess we're in afternoon now, so good afternoon.
No, and I know I printed out your worksheet and I said it. All right, Ms. Free, what'd you do with it? I know I printed out. So, I'm not real sure. So I know before he was paying $900 that he said was paying everything else. Now I believe, according to my notes, that Ms. Montgomery claimed yesterday that I think she had said, or her client said, he'd made about like, I think it was 13,000, something like that a month, 13, 14.
that he paid that.
That he made that.
Oh, I'm sorry.
That is correct, Your Honor.
And that's what they're saying as far as the gross, but he has his own business, so obviously he has the expenses of the whole entire business too. So that his net income is not that every month.
Yeah, well, that's the thing, is that with child support, you got to go by his gross. I mean, when you're self-employed, you could take some of those things out, but not all of them.
Right.
He had testified that he made about five. The other. Sorry, let me pull up my other.
Right.
I had two. Oh, there it is.
All right, I'm here.
I think his testimony was he made like 5,000.
I believe she said 3 to 5.
3 to 5, which, because on the child support worksheet, there's a place for self-employment. So I just had a couple of questions on this. So on here, I saw one that said separate assets and wife. So is there $16,000 in a joint checking account, Ms. Montgomery?
No, there's no joint checking account, Your Honor. The only thing that we provided was my client's financial affidavit.
You're gonna have to speak up, Miss Montgomery. I'm so sorry. I'm sorry.
Okay. All right. Can you hear me now? I was saying that no, there is not a joint account. What you received was the DERFA for my client only. And that did not include Mr. Breland's finances on that document.
Because I saw where it said bank account. Where it said bank account, it said, I guess you typed out joint checking account, and it went over and you put separate access, separate wife, you put 16,000, and you said a separate basis of claim, you put 200.
Okay, I think that was supposed to be amended. So if it was not, then I apologize for that.
Was it like 1,600?
Yeah.
Okay. I looked at it, I was like,
no, my client wishes, but no, unfortunately, that's not the case. Your Honor, we just want to make it clear that this was a temporary protective order hearing. And, obviously as one of the requirements when there are minor children involved is that the parties are to provide a DERFA along with their child support worksheet before the hearing. And so our position is that we would like a ruling today along with an amount of child support because the children, Mr. Breland has gone over 30 days without providing any sort of support to the children. And we really do not want to file an abandonment claim against him and have him put in jail. So if the courts could go ahead and put in an order, that would avoid us going after him.
And Your Honor, we just said that we understand that there's going to be a ruling today and that Mr. Breland is understands that the court is going to award an amount of support today. So I don't see that we've raised any objection to that.
Pull up so what she came up with on hers is $1,430 a month.
$1,430 a month for child support.
Right.
That's based off of 2 children, Your Honor, not 1. In addition to that, our client testified to, after being with Mr. Breland for over 10 years. I'm sorry, I'm speaking.
I'm sorry. She was
sorry.
asking me a question. So if you just let me.
I can pay
I'm
for
sorry,
it.
I was
Well,
speaking.
we are agreeing to what she said. So if you would just allow us to speak for once, then we could just agree to
I
that
would
amount.
appreciate if you would not interrupt me. I have had about enough of you,
And that's
so please do
totally
not interrupt me when I'm
fine.
speaking.
Your Honor, if you
Seriously,
could,
stop.
we agree to the
Just
amount that you have just stated. So I think that we could just avoid this unprofessional back and forth.
The most unprofessional here has been you. But
Ms.
okay.
Montgomery, what were you saying? Because is there a that was
Your
in
Honor, what I was saying is that my client had given testimony yesterday to how much Mr. Breland makes on a consistent basis. And even with that, we did not put the full amount because we do understand that he is a business owner. And so that is what we took into consideration. That is what I was going to say.
Yeah, so she imputed your client at $8,441. So it's kind of was like halfway in between what she said, and then she imputed or rounded it, and her client made $2,800. Did your client have? Does your client just have 3? Does she have 3 children?
Yes, she does, Your Honor.
So you didn't? Did you use the? Did you count the qualified?
I did not include the eldest child because that is not Mr. Breland's child.
So you didn't count that as a qualified child towards her?
No, I did not.
In the event, I don't know, Ms. Locklear, how much family law you practice, but she could also count that as a qualified child, which would make his child support go up. I mean, it's very little, maybe 20, 30, but anyway, because if he has any other children by anyone else that he pays support for, he has to be current on that support, but it would make his go down probably about the same. So is there any, are you going to go pro rata shares for anything out of pocket? Is that what you want to do?
Yes.
Okay, so this is based on out of pockets, Mr. Breland. You would pay 75% for anything out of pocket, and she would pay 25%. And Ms. Montgomery, we'll send you the form with the style. If you want to do like an addendum to add the other stuff specifics, you can get it to me. So he'll pay 75% of out of pocket. She'll pay 25%. And she has to give him the receipt for anything out of pocket within 10 days, and he's got 30 days to pay it. Is that good?
Yes.
He could pay that. Let's make it certified funds, or do you want Zelle or Cash App or something, one of those fancy things that I have no idea how to use?
And they've been using Zelle, I believe, before, and we could just do it that same way if that's okay with everybody.
Is that good with you, Ms. Lusk? Zelle or Cash App or what?
Zelle is fine.
Okay, so out of pockets, he could do that. So, Ms. Lusk, your attorney's going to tell you have 10 days. So if you go today for something and there's a copay, you have to send him a receipt of that copay. Okay, so he can send it to you. But that doesn't include going and getting Band-Aids at CVS. So let's not get into stuff like that. Okay.
Yes, I understand.
And is there, Ms. Montgomery, is there any, so there's not a child's like asthmatic or anything, that any sort of reoccurring medical expense. Okay. So
no, Your Honor.
all right, so we will make it so does he have that to pay for this month? Does he have it paid? Ms. Locklear?
What do I have?
So you're saying, will he pay the $1,430 this month?
Yeah.
I don't have it right now.
We can pay that on Monday.
Okay, do you want it once you want it on the 1st to the 15th to split it in half? Which do you want?
Can we do, well, we'll split it in half on the 1st and 15th.
Yeah.
So
Okay,
we'll make the first installation on the 15th then?
All right, but so all of it's going to be due this month.
On the 15th, right.
You make all of it due this time on the 15th, and after that you got 1st and 15th, okay?
You got it.
All right, so now here's what I say, all right? So it's due on the 1st and the 15th, so that's not the 2nd, it's not the 16th, and the
Absolutely.
1st and the 15th to me is kind of late, so make sure it's there on time, okay? So don't
Yes,
put it
ma'am.
postmarked or anything like that, and make sure
no.
that if these things charge like a 2 or 3%, you gotta add that in, okay? Because I don't
And-
like for
That's
And I
fine.
think that we're fine. I mean, we'll do it if you can order it the 1st and 15th, but I think that, I mean, honestly,
That's what I'm thinking,
if we need to
paying
do
for
it, yeah,
15.
one way or
Yeah.
the other, it's
Well, this, I mean,
No.
this is the same thing I tell everybody on some of mine, so they make sure that they know how to get it there. And we're going, and Ms. Montgomery, in the event that there is a legitimation, anything like that, you could put in there that we will, that the judge hearing that can modify this in any way
Sure.
that they deem necessary. So if there's anything else, is there anything what do you want to do? And I want to go ahead and do this. So, video visits or something with a child. And here's what I typically say is video visits with the children, and that I like to say that both parties can videotape it. That way, if there's anything that's said that's out of line, mom's got proof that said it was out of line, and then dad's got proof that nothing was said out of line. So that's what I like to say, because I'm assuming that if there's some sort of a paternity and or legitimation, that I could foresee a guardian in the future. That's
Mhm.
what I say. So, and most of the guardians that I have, they usually like that. Not videotaping it to, encroach on their privacy, but videotaping it simply for the fact of seeing if there's something that's inappropriate said.
Your Honor, I agree with that. I just wanted to be clear that there is to be, I don't know what your ruling is going to be here today, but our posture remains that there should be absolutely no contact with Ms. Lusk from either of these two individuals is our posture.
Except for, about it, and the contact between her and Mr. Breland is going to be, what's the name of that app? What's the name of it?
Family Wizard, Your Honor?
Yes, our Family Wizard. And it will only be, and so that's a small fee, Mr. Breland. It's a small fee, Ms. Lusk. But so you will get an email, Ms. Lusk, from Mr. Breland that will say he has signed up for it. And Mr. Breland, you will get an email from Ms. Lusk saying that she's signed up for it. So that's not going to be a violation, okay? Now, without our Family Wizard, Ms. Montgomery will go more into depth with you, Ms. Lusk. She will post something. So the only thing you need to send him is the little Johnny, I don't know, little Johnny broke a toe. You want to let her know that little Johnny broke a toe, you could do that. And Mr. Breland, that you would just say, thank you for telling me.
Okay, yes, ma'am.
That's it. Anything else, so that's just if there is an emergency, okay, until another judge, so y'all do the legitimation, and then they will change that if they need to, okay? So that's emergencies only. And then if she has to send the receipt, she'll send it through there. And that also, I'll tell you, it'll say how often you check it. So I don't know that she'll have that much to say to you about it, but I would check it every day. So it shows if she sends something and you never open it, it shows that.
Right.
All right. But Ms. Montgomery, if you put in there that they can, now if there's conversations going on and you're recording it on FaceTime or Zoom or however you want to do these visits, that doesn't mean that the other parent sits there and interferes with these calls. Does that make sense? So if you
Yes,
set
ma'am.
it up on Zoom or something, you set it up and you walk out. Now these children are
9 and 4.
9 and 4. Okay, the 4-year-old's attention is that a small fly. Okay,
Right.
you're not going to be able to keep the 4-year-old on there for long, and the 9-year-old probably not much longer because they're going to want to do what they want to do. So, what is a good time that they're not going to be enthralled in a game or television or dinner or something?
Malachi plays video games all day. So.
So,
So
Ms. Lusk, do you know a time that you would, and I don't know, and I'm not gonna say 30 minutes or an hour, we'll say like what, 5, 10, just a 10-minute, like, hey, how's it,
We
something?
can set up something. I mean, after school, I know is a good one. And then, if he wants to do weekends and talk to them, I know that they're anxious to talk to their dad. So I'd be happy to set that up.
So, Ms. Montgomery, what do you want to do? Do you want to leave it? Because I don't want them to have so much contact. You want a set schedule? What do you want?
We can do a set schedule. We could do like 3 days a week. Like Monday, Wednesday, and Saturday.
All right, Mondays and Wednesdays, give me times.
I need time to get home from work. So if you could give me till about 7 or 7:30 p.m.
So 7:30 p.m. until 8
Till
p.m.
8. And what if there's a reason that I'm delayed, which I'm not saying that I will be. I'm just simply stating I've got work and I got to pick them up.
Absolutely. That's what things happen. Life happens. You get on Our Family Wizard, you send him a message. That's why he's going to check it between 7:30 and 8 to see if something happens. Just like life can happen with him, that he may say, I can't do it today because life has happened, and y'all could switch. Okay, that's in case something happens. And on Saturday, what's a good time for Saturday?
Let's do in the morning for now.
Mhm.
I mean, let's do like 11 a.m.
So like 11 a.m. to 11:30.
That'd be fine.
And that's a window. I'm not saying they have to talk for 30 minutes. That's a window. Okay. Now, also, I'll tell you this, and Ms. Montgomery will tell you this, that the way that you two behave right now is setting up to see how this is going to go in the future. Okay. So let's all be grown-ups. All right. So is there anything else, Ms. Montgomery, do you think I need to? I think that pretty much covers it, right? So we'll put it in place for 12 months, and we'll let the judge, who's ever going to deal with anything else that's filed, modify it in any way that they deem necessary. And we'll leave it up that if something happens, if somebody needs to switch a day with the videotape, seeing things, that you two can agree to swap days. But, if you have to talk to her about something, Mr. Breland, maybe you want to let your lawyer call her lawyer. I hate to do that, but you may want to, or something, or you can email her, whatever. Okay. But through Our Family Wizard, if something happens, you can email her, but it's has to be about the children.
Yeah, absolutely. Yes, ma'am. I completely understand that. I just want to know why not 5 days a week? At least 5 days a week.
She says 3 right now, so just take what you got.
Okay, that's understandable.
Yeah, a legitimation.
I don't know
case,
why when I've been in their lives every day, but I get it. She wants to do this. So that's fine.
I don't either now, but you have your choice of a legitimation case, whatever y'all decide to do, y'all can do it. 6 of one, half a dozen of the other. But anything else that you guys would like to take up?
Your Honor, we filed an affidavit for attorney's fees.
And obviously we object to the attorney's fees.
All right, you want to file an objection, and I'll give you 10 days to respond. And
Yes, Your Honor.
what's the date? If y'all want to send me something, a proposed order at like, look at my calendar. What I got? Oh my goodness.
Also, I apologize for doing this. Can Miss Les tell me again what 3 days she specifically said? Because I wrote my notes times, but I didn't actually write down the dates. So can you tell me that again, Miss Les?
Mondays, Wednesdays, and Saturdays.
Mondays, Wednesdays, Saturdays.
Yeah. And obviously, if things happen, she could be flexible. Whatever.
Yeah, we can.
All right. So, wait, what is this? January. So, I know there's like holidays coming up. So, how about like by February the 5th? Is that good?
Yes, Your Honor.
So, you got 10 days to respond. And then, how about I expect if y'all want to send a proposed order really short and the statute proposed order for both of y'all by February the 5th?
Yes,
Will
Your
do,
Honor.
Your Honor.
All right. Everybody else stay safe and healthy, please.
Your Honor, do you want us to also prepare the final order
Yeah,
for
you can
the
prepare that. Yeah, you could prepare that, and if you want to put that stuff, and do you want to order, and then do you want our standard order, and then you could just do like a line 24, 27 C addendums?
Yes. I would
Okay,
just-
so Miss Free will email it to you with the style, and you could do that.
All right. Sounds good.
Ms.
Thank
Martin,
you, Your Honor.
do you have everything that you need, Ms. Martin?
Are we still coming back on the 12th for the other TPOs?
I don't know, was he served or what do we?
One was served, the other, we still don't have confirmation.
Uh, Were we given a time for the 12th, Your Honor? I did not receive, I don't remember we discussing a time. I know we discussed a date for the 12th.
Did we do it in the afternoon? Did we do,
No, it was 9:30.
it was 9:30, okay. Did that change for you? Did you have something?
I'm so sorry. Can I just clarify something? Mr. Breland just wants to make sure that he's clear on this. So 3 days out of the week, and obviously we talked about the flexibility of the schedule. Monday, Wednesday, and Saturday is what we have.
Is that video chat?
That's video chat that he'll get to do with the children, not actually see the kids, correct?
You see him on the video chats, right?
Okay, perfect. Just wanted to confirm that with you.
Until something else is filed, and then the judge, whoever hears it, yes, the 12th at 9:30.
And so we did file the petition for legitimation and all that, so we'll just go before the judge on that and then have a hearing.
Did it get accepted? Got a case number?
Well, we filed it actually in this case too, a couple last week before the hearing that we had scheduled for the 30th for both of the children,
So,
and it was
but
accepted.
did it get accepted there?
Yes.
Your Honor, this matter is not ripe before the court, and so it's not something that needs to be brought up during this hearing.
Right. No, I'm just going to see who that's assigned to for your own edification. Let's see. Who is 4 now?
I'm sorry.
I forget who 4 is now. Let's see.
I think it's Judge Farmer, Your Honor, if I'm not mistaken.
That used to be
Let me see if
Reader.
let me make sure I'm
Glanville.
saying that as Glanville. Oh, okay.
So it looks like right now there's a March the 21st at 10 a.m. on that.
You say March the 31st or 21st?
March 2nd. I'm sorry, March the 2nd is the
Oh,
30th.
okay, thank you.
But I mean, obviously it hasn't been serviced. So, but
Correct.
all right, so it is Glanville. So that's what I'm talking about. So once you get in that something there, if there's service or whatever, if you guys want, I'll be and you need something, I'll be glad to sign an order for a guardian or something in that to get it going. But everybody, until then, y'all stay safe and healthy. Have a good week.
Thank you, Your Honor.
Thank you.
Good week. All right.
I'll be emailing your bills momentarily.
Perfect.
Of course, of course.
Have a
Thank
great,
you.
safe weekend, everyone. Thank you.
Thank you, Ms.
You
Martin.
guys too. All right. Let's see, Miss Allison and Miss Free. Y'all stay on. Let's make sure we go over this calendar.
Sierra Breland disappeared in late February. Her husband, Xavier Breland Jr., reported her missing to Carmel police shortly after the couple went on a trip to visit family in Georgia. Not long after, police said they don't believe Sierra ever made it back here to Indiana. Xavier Breland Jr. has been named a person of interest in Sierra's disappearance. He's in jail in Georgia now. He's facing charges in a different case that include aggravated stalking, harassing phone calls, and violating a protective order from a woman who is the mother of
County
his
Jail,
child.
where he's facing charges unrelated to his wife's disappearance. Xavier Breland sat silently and listened. He was in this Fulton County hearing with his attorney because his ex, the mother of 2 of his children, asked the judge to suspend any contact Breland has with their 6 and 10-year-olds, including video calls they've been doing. The argument was the children got very upset after Breland addressed the disappearance of his wife with them 4 days after he reported her missing. He reported Sierra Locklear Breland missing in late February once he was back home in Indiana after the couple had visited family in Johns Creek. Police named him a person of interest in her disappearance.
The children are being harmed by continued contact with Mr. Breland.
I think there had to be some explanation to the children why she wasn't a part of these calls.
Judge Alex Manning watched the recorded video visitation of Breland speaking with his children about his wife's disappearance, which was not played in court for everyone to see.
What I saw in that video was heartbreaking. It's heartbreaking. This little girl falls apart in 2 minutes. uncontrollably sobbing.
The judge calls it cruel.
This conversation seems to escalate to now, nope, she's been kidnapped. You know what that means? She's never coming back. I don't know how you know that, but you seem to know that she's never coming back. And this is just traumatizing these children over and over and over again.
Sarah Locklear Breland was last seen on February 24th, 2022 in Johns Creek, Georgia. Her body's never been found. Xavier Breland Jr. remains the only person of interest, is now serving a 12-year sentence in the Indiana Department of Corrections for being a violent felon in possession of a firearm.
If you're involved in a dispute with another party such as this and you just can't seem to work it out, don't resort to taking the law into your own hands.
We'll hear the litigants reach.
All right, thank you very much. Officer Burrell's waiting for you, and that will bring this case to a conclusion.